So, hello everybody. Following our 42nd International Congress on Intellectual Property here from the Brazilian IP Association. We are very happy and would like to thank again ABPI for this floor, for this panel about one of the most vibrant and interesting aspects related to games, entertainment, relevant aspects of intellectual property. And we are more than happy. I'm Marcos Blasi. I'm a partner at the Guzmão y Bruni and a member of the board. And also I'm very happy to have here this very special guests here that we're gonna share their extensive knowledge about the matter. So the idea here is to go and switch quickly to our speakers. So I'd like to pass the word for Mr. Bruno Miranda, who is a senior lawyer and in-house counsel of Riot Games, and who have extensive experience with this field. I'm gonna share the general aspects and the landscape of games in Brazil and worldwide. So, Bruno, the floor is yours. Thank you again for being with us.
Thank you, Marcos. I'm very happy to be here. So the idea, and I'll get right to it. So kind of the idea of the first presentation, I'm going to jump in and give a little bit of an overview of the gaming market, because the idea is to kind of put things into perspective before the other presenters can kind of start on, diving in on more legal aspects related to the gaming industry. Let me share my screen here and let me see if, if it works out. Showing? Oh, good. All right. But before we actually dive in, I would like to start with a video. Hopefully, it plays all right for you guys that are watching. Can you hear the sound all right? All right, I hope you guys enjoyed that. So the reason for actually playing that video is because, it's just a way to illustrate how the gaming industry has moved outside the gaming itself for, a long time. The gaming industry has been trying to find, new ways and to connect with the players, with their users. And, right now is actually at the center, I would say, of creative industries. There's a lot of synergy with gaming and music and audiovisual works. That is something that we are going to talk a little bit more further down the road, but it's a little bit tying into this on saying the gaming world is massive. When we start to look at the numbers, and this, just before we actually, kind of dive in and dissect this, it needs to be taken with a grain of salt, because of course these numbers are part of one research, one survey. This is the source right here is Newzoo, but there are different methodologies, in the market that the numbers might vary a little bit, but nevertheless, I would say that it's a good source to kind of feel and understand the scale of the industry. So when we look at the numbers of gamers in the world, that we are over 3.3 billion users worldwide, which is a lot of people. The estimate of the survey that came out in July last month is actually that the industry is reaching $200 billion in this year. So, and 53% of that is coming from mobile games. But, I would say kind of the important part is not only understanding the numbers themselves, but understanding how the industry has changed, in the last decades, in the last years, So when we think about games, and a while ago, you remember games were kind of a finalized package, you would buy them on a cartridge or on a disc or on a CD, and that was it. You bought the product, you paid a fixed price, and then you played it, and that was it. The industry has changed a lot from that, especially when we think about what we call the AAA games, which are games which are the biggest ones, produced by the major publishers and developers. They cost a lot, they take a lot of resources, they cost a lot of money, they take years in production. So the industry needed to find a way to actually, kind of, carry out and kind of expand the life cycle of the game. So you remember a few years ago, they started doing the DLCs, right? So you release a game, and then after a while, you would release an expansion pack, right? New stories or new missions, etc. Something that would expand the increase the experience from the previous game. So that changed a little bit on how they were. So also, distribution, the games themselves, they moved. They still have the physical copies, but that has been diminishing gradually. Right now, I would say most of the distribution happens with games on a digital form, which brings new possibilities, and also the way that the industry has, started to monetize games has changed a lot, because it's not only now, the price on a pay-to-play way, you put the game behind a paywall, you need to pay in order for it to play. You also increase the DLCs, the expansion of the games, but also microtransactions. Microtransactions are basically when you buy, to change, let's say, skins of the game. You want to personalize the experience. You're changing the way that the character looks. Or then there are what they call the pay-to-win microtransactions, where it affects gameplay. You're buying something that it is going to change a little bit or give you an advantage on the game itself. Let's say it can be an experience booster. It can be unlocking maps. It can be I don't know, like a weapon or something, an item, a digital item that it makes a difference in the game. So and we kind of divide the market, I would say, into consoles, PCs, and mobile. I would say consoles and PCs are fairly similar, but the mobile gaming industry is completely different. The monetization scheme for mobile is mostly free to play. You don't pay to play the game in itself, but most of the revenue is coming from microtransactions. It's coming from buying these extra items. And I would say, since the cost to actually play, like everybody, the inclusion, the number of smartphones across the globe is massive. Also, the opportunities for you to play, because you can play in transit, you can play when you're, on a bus, on the subway, etc. That kind of boomed the mobile industry. And now, even the companies who were more focused on consoles or PC games, they're moving some of their biggest titles to mobile gaming. So when we look at the numbers here in Brazil, from a population of 200 million, we have like around 19 million people playing games, and 53% of that are payers, people who spend money on games. That basically puts us on number 5 in the world, in number of payers. China is not here on the globe, but China is by far the number 1, and that's driven mostly by mobile gaming. China has, the number of payers is more than double than the US, so it is a massive market, and in Brazil it's the same. Mobile gaming is actually number 1 in platforms. So, and there's not a lot of difference between number of men and women playing. It's fairly balanced. And then consoles come, and then next by last it's PC gaming. You guys probably heard about this before, that the games industry is bigger than music and film combined. We can see by the start of the graph, years ago, a couple of decades ago, they were fairly similar, but then the gap has kind of, it became so wide in the last decades, which is even kind of hard to pinpoint one specific reason for that. I would say, and that's a little bit of the difference on the product itself, but games, they bring this immersive experience more than the other ones. Like you dedicate a lot of time to games, you're fully immersed in the different worlds, etc. So I feel that the level of connection between players and the product is a little bit different from the other industries. We can say that all of these, they compete, for attention. They compete for people's attention, because there's so much free time that that a person can spend on choosing what to do with that. But nevertheless, I would say that nowadays they're finding more and more ways to collaborate, to find the synergies where they can leverage one from the other and expand their businesses. If you think about Travis Scott during the pandemic, playing a live concert on Fortnite, that's one of the biggest examples that can be, leveraging the music industry within, a gaming platform. So, and the pandemic, of course, it was, a period where, I would say the gaming industry kind of boomed. And like you said, this quote from Chris Plank from Polygon, it's something that, it was already kind of normal for a lot of people. It was, important for a lot of people, but then others also kind of, embraced gaming as a way to connect with friends, as a way to spend time. And then it was kind of a moment that when I would say kind of the industry took some leaps, nevertheless, it was not all only flowers, I would say, because the industry was also hit by the pandemic in, a lot of delays on releases of titles, the teams having to work at home, which was a completely different dynamic. Also on manufacturers of, the gaming devices, consoles, they were also hit by all of that crisis, that happened about microchips and the shortages, etc. So that kind of all affected the industry itself. Now that we're kind of moving away from, the tougher days of the pandemic, of course, I'd say there's kind of a reduction in the growth, margins that the industry was going through, but nevertheless, it's not necessarily something that is not going to continue to grow in the next years. Talking a little bit about Riot Games, these are the titles that Riot Games publishes. League of Legends was the first one. It is kind of the main game in the company. It was released in 2009. Other than Valorant, League of Legends, Wild Rift, Teamfight Tactics, and Legends of Runeterra, they all kind of build from the same characters, from the same lore, from the same kind of world, but they are different styles of games. Valorant now, it came out during the pandemic in 2020, and that's a first-person shooter. These first 3 games, League of Legends, Valorant, and League of Legends Wild Rift. Wild Rift is a game now for mobile. Like I said, publishers trying that weren't in the mobile industry now moving in and bringing some of their more important titles. And these 3 are games that Riot has competitions and leverages on esports, which is kind of the next topic that we're going to go through. Esports, they also kind of became a little bit more known and kind of mainstream during the pandemic. I would say when sports in general stopped, esports were one of the only kind of alternatives that were available for broadcasters. So a lot of these broadcasters started, because the players could play it from home, and they started, to going after some of these, some of the companies that organize esports in a very structured way to, broadcast their content, and so like last year, these numbers here, it moved just the esports like $1.1 billion. So it is a massive market. CBLOL is one of the most kind of famous tournaments in Brazil, and CBLOL stands for Campeonato Brasileiro de League of Legends. So it is, based on League of Legends, and then we have CBLOL Academy, which is kind of like a tier where players that are starting out, they play, is a more kind of a step to evolution, and then it goes to CBLOL, the teams. But CBLOL now is actually kind of a closed league, because the teams are part of it. So our 10 teams, which are the same ones. And then they have the different formats, and, broadcast combined with streaming on platforms like YouTube or Twitch, it is massive. We have pay TV as well on Sport TV, but then it is, getting attention of a lot of people. The numbers are impressive. The games, and like I said, now moving into a little bit on, how the ecosystem is not limited only to games. I would say the gaming industry, there's so much appetite for, content that transcends the game themselves, the games themselves, that transcends that, consumers, they want to know more about their favorite characters. They want to expand stuff. They want to create, content themselves, et cetera, et cetera. So Riot Games has, been kind of, providing these new opportunities for immersive experiences. So within music, for instance, Riot released, albums for KDA, which is a K-pop group formed by, some of the players, the champions that we call them on League of Legends. Another example is Pentakill. Pentakill is actually when you play the game and you kill all 5, players from the other game yourself. That's a pentakill. So they actually formed a band, a heavy metal band. That they have 3 albums already released on streaming services, and that generates a lot of attention. Players love it. And when it comes from digital to more traditional forms of consumption like paper, comics, there's a lot of appetite from that as well. So there are, players love, and then we have, all of these kind of synergies, with different industries in Marvel, for instance, on telling the stories of our players, the lore, what we call, which is kind of similar to folklore, but it is what kind of what encompasses the whole world of the game. This, if you guys have not watched it, I urge you to do it, because I would say it's a great example of the gaming industry doing and doing content that worked. So Riot actually produced this and has been kind of producing Arcane for a number of years. When they felt that it wasn't on the status, on the level that they wanted, they actually kind of erased everything and went back to the drawing board and restarted the process. So it came out on Netflix. It was fully produced by Riot and Fortiche, but it came out, it was distributed on Netflix. The show itself, it won 3 Emmy Awards recently. It won like 9 Annie Awards, which is kind of the Oscars for animation. If you go on IMDb, like myself, who likes kind of see these ratings, they have like a 9 score, which is massive. So and this is actually, I would say, it's kind of it's a good cycle where it brings new players, it interests new people who haven't had any connection to the game itself, but nevertheless, it also kind of reinforces and reignites the passion of the players themselves, who see that, and they can see, the Easter eggs and all the stuff that they've been kind of consuming for a while on screen, So I would say this is one of the kind of great examples of gaming being at the center of the entertainment industry and bringing all of these together. That's it. So I know I'm running out of time, so I'm having a look here at my clock, and then I'll give it back to you, Marcos.
Fantastic, Bruno. Thank you so much, including for being so strict regarding the time. Thank you very much for that. It's a very synthetic, but at least very comprehensive presentation, and brings all the color we needed to and the big panorama, the big picture, in order to exploit a little bit more the IP implications that are very, very relevant, including because of this new experience for the user, for the gamer, in terms of crossing music and games, a lot of experience, very, very rich experience. So I will have the pleasure to give the floor now to my partner, Gabriela Lima, who is the head of our media and entertainment area, and going to exploit a little bit the IP aspect, the most relevant issues regarding gaming in Brazil. So, Gabriela, the floor is yours.
Thank you, Blasi. Let me share my screen here. Could you please tell me once you can see my screen, please?
We can see it.
We can see, and if you can put in the presentation mode would be fantastic. But we are seeing the PPT number one.
Okay, just let me know if it is on presentation mode already. Is it?
No, at least for me, not yet. I also, and I don't know if you can put larger at the screen, but we can see. But
let me see if I can switch the screen that is supposed to be on presentation mode.
no problem at all. Yes.
Would you be so kind of sharing my presentation? Do you think you can do that?
Let me see if I'm able to do this.
Maybe if I share my screen, let's see if it solves my problem or not.
Let's see. Let me test here, just a moment. Let me see.
Okay. Yep.
Can you see?
Yes, I think it's not on presentation mode yet.
And now?
Yes, okay.
I will pass and just guide me.
Thank you very much. So I'll be talking about some central IP aspects. I decided to just pinpoint some importance aspects of protection of IP rights in games, also the importance of contractual arrangements, and the importance of content risk assessment. We can move forward, Blasi. I would just like to introduce and give before jumping into the protection of intellectual property rights, just give this a very brief framework. The idea here is to show how complex the environment can be and the framework of the gaming industry can be. In the center here, we'll have the publishers and the developers. Of course, they are the ones that are responsible for creating and publishing the games, and of course for those entities, the protection of intellectual property rights is very important, and as well as the contractual arrangement for exploiting those kind of games, and also for securing the protection of intellectual property rights, which I will be talking a little bit further in a while. Also here, I would like to highlight the importance of the distribution agreements. As Bruno said, it depends on the, if we're talking about cloud gaming, if we're talking about mobile gaming, if it's download, but all of this part will be on a digital distribution. And on the other side, we have the console distribution, all of this necessary for the games to reach the gamers, its publics. And here on the side, I decided to highlight the esports leagues, but of course here we have a very wide range of possibilities of exploiting these intellectual property rights. So here on the esports side, we would have the importance of the broadcasting rights, negotiation of the broadcasting rights, so these esports, these events can reach the fans, and also the rules and regulations that the team should comply with in order to participate in these leagues. And here also in all of this framework, we would have some agreements with influencers, sponsors, and advertisers, which have been taking advantage of the gaming industry to associate themselves with the gaming industry and to explore a little bit this universe as well. We can move forward, Blasi, to talk a little bit about the protection of the intellectual property rights, which is the first aspect that I wanted to highlight here in this presentation. Of course, we have different assets that may be protected when we talk about this industry. Taking, for example, Sony Interactive Entertainment. One of the, of course, we have the institutional trademark of Sony, but also the institutional trademark of their division of game development. So PlayStation Studio is the division of game development of Sony. So there's also this trademarks to be protected. One of the games that they publish is here Gran Turismo. So of course, we also have the trademark of the game itself. Looking at the game, we also have different protections that we could be talking about. The software protection, which would be basically the protection of the source code of the game, but also the copyright protection. And here, once again, we have a wide variety of possibilities of copyright works to be protected. We have the different elements of the game, so the soundtracks, the characters, the storylines, all of those that could be protected by copyrights. And when we're talking about the protection of the game itself, there is a discussion regarding the legal status of the video games, basically because of its two main parts. So of course, the software part and the audiovisual elements. Of course, depending on how it's framed, as a consequence, we would have different scopes of protections and also different durations of such protection. Here in Brazil, it's the most common interpretation by intellectual property experts is treating video games as audiovisual works, and that would be because of the artistic aspect, especially with the industry development that Bruno was talking about. Games nowadays are very, very sophisticated. So most part of the Brazilian IP experts would treat video games here in Brazil as audiovisual works. Also, in terms of industrial design, coming back for the examples that we have here, we have PlayStation console, we have the controllers. All of these could be protected by industrial designs. And last, we can also have patents protections here. The patent could protect not only the hardware involved, but also even gameplay methods. And in terms of patent disputes, Margaret will talk us through some patent litigations that happened in the US. So maybe we will have a little bit more about her experience on those cases as well. Blasi, if we could move forward to the contractual arrangements, and the first category, let's say, of contractual arrangements that I wanted to highlight are also contractual arrangements that are very important for the protection of the intellectual property rights. So here we have the agreements with the authors of all, we have all of the copyrightable works, but I would also say not only the copyrightable works, so the soundtrack composers, designers of the game, of the graphical games, so all of these authors that contribute with creative elements of the games. And if we take, for example, here The Last of Us, which is a game from Naughty Dog, this game is remarkable for the complexity of its creative elements. So the narrative is very complex. The visuals and the sound designs of the games are also very remarkable. So in these types of games, and when we are talking about all of the aspects of the games, so those artists that are somehow contributing with creative elements of the game, it is very important to make sure that Naughty Dog and whatever the company is has the employment contracts or even services agreements with these authors. And here in Brazil, it's very important to that those contracts have provisions of copyright assignment. When we are talking about the game developers, specifically game developers who are responsible for developing the software and the source code of the games, in this specific case, we would not need an express provision of copyright assignment, because once again, we are talking about a contribution, a software protection here. And as we know, the Brazilian software law establishes that the software rights, they belong to the contractor, the employer. So it is important to have those contracts, but differently than the copyright, the copyright contributions, such as the soundtrack and so on. There is this difference regarding the express provision of copyright assignments that will be needed in some cases. In other cases, it's not essential. Let's move forward for other categories of contracts here. The distribution contracts, of course, also very important. Once again, taking a look at an example. Here at Diablo's case, we have Blizzard Entertainment as the publisher of the game, of course, Blizzard. So here in this example, we have the distribution agreements between Blizzard and Apple, also with Google. And what is interesting here is that Blizzard also owns its own platform, Battle.net. So in this case, Blizzard also distribute the game, has its own possibility of online distributing the game for the users towards this Battle.net platform owned by Blizzard. We can go to the next one, Blasi, please. Here, Bruno talked us through a little bit about some possibilities of exploitation of derivative work. So here, basically, any kind of derivative work, so any exploitation of any works that is based on a game will depend on the authorization of the company. In this case, in the case of Riot Games, as Bruno told us, Riot was responsible for producing the series. Arcane was also responsible for publishing the comics and the books. But of course, if we have a third party here that is interested on exploiting those derivative works, once again, we will need the necessary and the proper contractual arrangements with the owner of intellectual property rights to enable such exploitation. On the next one, we have another way of exploitation of intellectual property of the games, and here is exploitation by the esport leagues. In this case, here we have the example of Free Fire, which is a game from Tencent. They have the Brazilian League of Free Fire, which is this one right here in the center. And on the right side of the screen, I believe you're seeing on the right side also, we have some of the teams that participate in their leagues. Besides Team Liquid here, which is one of the biggest and one of the leading professional esports organization, we also have names here that are very well known by the public, at least here in Brazil. Vivo, the telecommunication company, Corinthians is a very big soccer team, and Netshoes. These are all big companies that have partnership with esports organizations. And once again, this is a way, it could be through a sponsorship agreement, it could be a partnership agreement, but the point here is that those big companies are also in a way trying to associate themselves and be part of this environment, of this ecosystem as well. And on the bottom of the page here, we have also some important ways of also exploiting and broadcasting or streaming the events to the public, to the fans, right? So here we have Booyah, which is the streaming platform of Tencent, and also the other on our right side here, we have YouTube. So YouTube needs this broadcasting agreement with Tencent to broadcast Free Fire, the Free Fire Championship, and also Space, which is a Warner Media TV channel on pay TV. So also broadcasting on pay TV, the championship, and also besides the pay TV broadcasting on Space, also the online broadcasting by YouTube. Now moving forward to here, the last contractual arrangements, the last category of contractual arrangements that I wanted to highlight here. We also have wide range of possibilities of exploiting those exploiting games on partnership marketing. So basically here I brought three lines of examples. All of those are examples from Fortnite, which is a game from Epic Games. So in the first line here, we have some in-game advertising. So here we have just what could be a traditional model. So an outdoor, a McDonald's outdoor, but the different is that when the players are interacting and playing the video game, they are going to be, and they will see this outdoor while they are playing. And also on the right side, this is an example of São Paulo LGBTQ Pride Parade. It was a campaign from Doritos. So once again, they just inserted their products or the trademarks for advertising purpose inside the game. Here in the middle of the screen, we also have in one side we have this classic sponsorships on football shirts, which of course are very common way, very common and traditional way of sports sponsorship. But on the right side here, we have something different, which is basically we have Santos emblems on the skins of the characters of Fortnite. So here, as Bruno said, the skins is a way of doing microtransactions in the game. So here the partnership was basically allowing the users of the game to buy the skins that have Santos emblems. So another type of partnership that we can have in video games. And last but not least here, this is a very I would say it's a historic event that happened in Fortnite. Bruno also this musical event. These are of course a very complex partnership to have an in-game concert. I would like to say that according to Epic Game, like just to highlight the importance of this event, it's of astronomical. In Fortnite, Epic Games said that there was 27.7 million players that were participating live in the event. So they were not even counting the players and the users that were then somehow accessing the game and accessing the event. So live, there were 27.7 million players. Of course, a very high number, very relevant audience here. And in this event, so besides, of course, Travis Scott performance, which was made by an avatar of Travis Scott, we also had lots of different skins that were available for the users to buy. So once again, another way of monetizing the games. And besides this, and skins and different items available for the user to purchase the games. Inside the game, inside the economical concert, there was also the possibility of purchasing different merchandising. So they really thought this through about different types of different ways of monetizing these events. So that's a very relevant example as well of a partnership here exploiting video games. And just to wrap up here on the key intellectual property rights, aspects that I think that are very important in the context of games. We also have the content risk assessment. Here, basically, the idea is to assess the game itself and see, identify potential risks related to the game exploitation, assess each one of the third-party rights that might be implicated here individually with the purpose of avoiding claims. And I think that Margaret will bring us some examples that are related here to these four main aspects that I highlighted here in the presentation. But basically, the purpose here is to avoid claims, to avoid litigations, even convictions, while exploiting the game. So here in the example of NBA, of course, we have lots of different trademarks. The Lakers trademark is just one of the examples. We have image rights of the athletes, just like we can see here, LeBron, the athlete LeBron James. We also have lots of different sound recordings here, so we need specific deals also to release the use of those works as well in the games. And other third-party rights here, we highlighted the tattoos of the players. I believe that Margaret is actually talking specifically about this case. But also I was paying attention on the video that Bruno was sharing with us right in the beginning of his talk, and we saw the video of Valorant's character raise. I think it was a video introducing the character, right? And of course, we had as a central element the music, which is protected by copyrights. Of course, there's the necessity of a release there. But besides the music, we could see. I was writing down, and there we could see lots of different street arts in the video. Some point of the video, we saw a choreography being featured, being portrayed at the video. There's also an important architectural work, Elevador Lacerda, a very important landmark of Salvador, and all of those different aspects. Of course, these are just some that I wrote down while watching the video, but of course, all of those different aspects must be analyzed for and assessed. So do we have any statutory defense to use such rights? Do we need a release from the rights holder? Of course, in case of Elevador Lacerda, for example, it is a work, an architectural work that is in public domain, but for the other aspects, maybe we would need specific releases for such exploitation. So not only on the game itself, but also on the advertising, all of the advertising work related to the game's exploitation. This is what we are calling the content risk assessment, is also a very important part to avoid, once again, claims that Margaret will be showing some examples to us right now.
Okay, thank you very much, Gabriela, for your comprehensive speech. And of course, as Bruno mentioned before, not everything is flowers in terms of gaming. So I'm more than honored to have here is Margaret Eskenet, which is who is a partner at Finnegan, with a broad experience in both advising and also representing entertainment companies and so on. So Margaret, it's very nice to have you here, and please share your thoughts. And I just let the audience know that because we're running out of time, in case you have any question and that is not responded here, we will be more than happy to share it with our speakers here. So I will pass the word to Margaret. Thank you.
can't share my screen until the previous screen is gone, unfortunately.
I will stop sharing here in this moment.
In the meantime, while we work with that, thank you very much for having me. I very much appreciate it. Again, my name is Margaret Escanay. I'm a partner at Finnegan in the Washington, D.C. office, and I work on copyright, trademark, and advertising issues in a variety of industries, but specifically in new and emerging media. And so video games are right up my alley. Unfortunately, my background is blurred, but I do have my gaming chair, and I have my my mascot that I brought with me for good luck. And it looks like now I'm able to share my screen, so I will do so now. Hopefully this will work and we won't spend too much time making it, we will not make the perfect the enemy of the good here. And hopefully this will just get us what we need. So hopefully you can see my screen. Can you confirm? No, not yet. One moment. Can you see my screen now?
Yes.
Yes, fantastic. Okay, I would put it in presentation mode, but somehow that went awry last time, so I think we'll pass on that this time if it's okay with everybody else. And yeah, I suppose I'll try and see if it helps, but no promises. Maybe that's presentation mode. Who knows? It is. Yes. Okay. Somehow it changed. It went to the wrong slide though. So see, you never know. All right. Thank you very much again for having me. Since time is short, I'll try to go quickly. Because I only had 15 minutes, I thought I would just cover the most important aspects of the IP issues, litigation issues in gaming, which are trademark, copyright, and patent. And I only say most important in the sense that those are the core core IP issues. And one very important caveat here is that I am only speaking with respect to US litigation and US law. I think that's critical because, for example, what Gabriella just said about the difference between software and other rights, that's a distinction that's probably not recognized in the United States. And that's just as an example. So please keep in mind, and the risk assessment would also be very different here, and we'll talk a little bit about that. But I do want to mention before we go on to the trademark, copyright, and patent issues, that if I'd had the whole hour, you would have had a lot more coming from me on other issues that are equally important. And I call them the cousins of IP protection. That includes trade secret issues. It includes advertising and regulatory issues that are critical in the United States. The Federal Trade Commission, which is the arm of the US government that deals with false advertising and consumer protection, recently filed a complaint against Roblox and Fortnite for the failure to disclose advertising in its games. And also they're always being investigated for, especially mobile games are consistently being investigated for inappropriate advertising to children. There's also privacy concerns, massive privacy concerns that would be part of what I would do when I'm doing a risk assessment. But today we're just going to focus on trademark, copyright, and patent. So let's talk about trademark infringement in the gaming space. In the US, what's really important to know in the US is that we have what's called a First Amendment rights. The First Amendment is a reference to the United States Constitution and the First Amendment thereof. And the First Amendment has 5 protections. The most important, or excuse me, the most relevant of which here is that we have very broad free speech rights in the United States. And those rights can often bump up against copyright and trademark rights in the United States, but the free speech rights, not always, but often prevail. And so when you're doing that risk, and that goes to the risk assessment issue, in the United States, the bar to determining whether the use of a third-party trademark in a video game rises to the level of trademark infringement is actually very high, because you have to show that not only is it confusing to consumers, that is that consumers actually believe that there might be some sort of affiliation between the trademark owner and the game, but that the use in the game is artistically irrelevant, which is almost impossible to prove. Why would you include a trademark that's not even remotely artistically relevant? And it's not explicitly misleading. So there's a test in the United States that really focuses on how, not so much how a consumer is going to perceive the test, but that's important, but really the intent of the artist when creating the game. The game is considered an artistic work and is going to be protected in the same way that, say, a book or a film would be protected in terms of being able to make an artistic or political or otherwise important or even not that important public point. And I will show you the distinction between a potentially important public point and arguably a less important public point. So let's look at the two cases that are the most relevant here. One of them is fairly recent from 2020, and the other one is an oldie but goodie from 2008 from the Ninth Circuit Court of Appeal. So let's look at the Activision, what we call the Activision case. In that case, AMG, that manufactures the Humvee, and Activision used the Humvee that depicted a Humvee in the Call of Duty game, and so AMG sued for infringement of its trademark rights in the name and image of the Humvee vehicle. And the court used that First Amendment test. That is, right, like, well, this is a game about war. This is a war vehicle. A Humvee was originally created for the purposes of being in a battlefield. And so the court, using what we call the Rogers test, that's the test that I just discussed about what's the artistic relevance and is it explicitly misleading, the court found that because this is a game about war and the use of the Humvee contributed to the sense of realism and lifelikeness conveyed for the player, that was a sufficient narrative purpose to allow the use of the Humvee image in the game without permission from the rights owner. So, you know, arguably, the U.S. military operations, even though it's a game of Call of Duty, you know, that's a clear example of an artistic point of view on that issue, right? So the next game is the 2008 case. I think is actually also really important because I think on the surface level it seems far less important. In this case, there is a adult club in Los Angeles called the Playpen. And in the game Grand Theft Auto, they didn't use the exact name, they called it the Pig Pen, but otherwise it had the exact, very similar or identical features of the Playpen, and it was clearly intended by Rockstar Video to emulate the Playpen. And that's how users, and my understanding is in the case, in the facts as they were developed in the case, the court did find that consumers understood, that the relevant and knowledgeable consumers understood what this was. But nonetheless, the court held two reasons: that there was artistic relevance because the game was set in a real place in Los Angeles, and they needed to be able to have a realistic depiction of this game. So and even though the realistic depiction was just happened to be in Los Angeles, you didn't need it to be in Los Angeles. They did change the name slightly, but you know, what's the relevance of a strip club? Why couldn't you have made it something else or a totally different adult club? But the court, again, because of those really strong First Amendment rights of the United States in terms of the narrative construction of a game, held that this was a protected use. These are really old games because we are actually having a hard time finding a trademark party that prevailed recently in a video game context. So these are really old games. This is kind of more, I think, more traditional trademark infringement. This isn't a use within the game for artistic relevance. This was really more of a copying of the name of the game or of the games. It was the gameplay was similar. The works were very similar, and so in this case the marks for the game itself were similar in both the Galaxian cases and the Scramble cases. And so in that case, because it wasn't in these two situations, the relevance wasn't to the game play and how a player might interact with the game, but actually the name itself, in an attempt to confuse consumers to play the game in the first instance. The courts held that these were in fact infringing. But note that they're both from 1982 and might be a little bit more, that there's a potential at least for some more a more challenging situation now. So I think it's important to understand that the trademarks will have a different outcome if you're talking about the gameplay itself, the narrative of the game versus the name of the game as a whole, or the look and feel of the gameplay, where you might have something more successful might happen. Let's turn to copyright, which I know is kind of the most commonly litigated part of issues in the U.S. And so I know I only have 5 minutes. I'm trying to power through quickly here. So we've got three cases, each of which are illustrated. Lakers are my team, so go Lakers. LeBron here is this has to do with the tattoos. Now that maybe you don't know, but there's a whole line of cases where tattoo artists are suing video games for the use of tattoos in the video games. And the reason these cases are actually really interesting is because the photography tattoo cases, those have been essentially, the courts are finding a fair use under US law, which is a critical exception to copyright infringement in the United States. And we'll talk about fair use in just a second. But so where you're taking a picture of the player and or of anybody, and they have a tattoo, and you're using that picture, the courts are pretty easily finding fair use. The distinction that's being articulated in video games is that you're not just taking an image of the player as they exist, but you are recreating the tattoo because you can't. These aren't photographs of players, right? These are people who are programming software to recreate the look and the feel of a player. And so they have to, so you have to make an affirmative effort to recreate the tattoo. Unlike a photo, you'd have to have an affirmative effort to remove the tattoo. Here, it would be easier, arguably, to have a player that does not have a tattoo, because that's just one more programming challenge to meet and execute. So, the tattoo company sued the video games, and that was how they distinguished the earlier litigation or the earlier cases about photographs. But the court did not buy this position. They argued that the tattoos were de minimis, that is, they're very small or significantly reduced in size. It was a fair use. It was transformative. That this wasn't no one looking for a tattoo would not satisfy a tattoo consumer, right? Like if you wanted a tattoo, the exact same tattoo that LeBron had, buying the video game, the NBA game was not going to satisfy your desire to have that tattoo. And so the court held that it was fair use. I also think that there's probably strong implied licensing defenses that could have been asserted. I mean, if you put your artwork on a human person, you're probably expecting it to be seen by other people and potentially photographed, etc. So let's move to the next case, which is a recent case out of the Eastern District of Texas. In this case, there was a professional wrestler. I don't know if you're familiar with G.I. Bro, but he is kind of I wouldn't say a niche comic book character. Some people know him. Oftentimes people are familiar with this poster, which is the one on the left. If you know this kind of genre, and again, Call of Duty allegedly infringed the G.I. Bro character by creating this character and also having the same, arguably a similar poster for the game. It doesn't look great for the wrestler at this moment, G.I. Bro, but it did survive a motion for summary judgment, and the case is actually still ongoing. We thought it might settle after the court decision on a summary judgment or the motion to dismiss, but it continues on. So I expected a settlement, but it doesn't surprise me that Activision is fighting it to the end, because they want to make sure that they're not hit by these kinds of suits more often. So we'll see how that one goes. And then another case that's ongoing is a newer case. There was a skater, this is a skateboard design that was used in a video game, and graphic artist Humston sued Jack Black and Tony Hawk and the people who made the game because these were photographs that are these weren't actually in game. These are photographs that were used to promote the game, and that goes back to that asset. I would add one thing to Gabriella's discussion about going over assets, which is if you're not just using stills from the game to promote the game, then you need to start looking at your advertising campaign too and see if there's anything in there that has potentially issues. I've been involved for years now with an advertising claim around a video game, so it's not the content of the game at all. It was some advertising for the game, and we've been litigating that for years now. It's a consumer class action, so be careful about not just the game itself, but the advertising for the game. And we're following this one closely too to see whether, because I mean the designs are arguably pretty close, so it'll be interesting to see how this works out for this graphic artist. Just quickly, I don't have a lot of time, or any time maybe even. So just quickly, this is how the courts determine whether there's a fair use. It is an I know it when I see it standard. It's very difficult to know ahead of time. You don't know, like for a while, the courts were kind of swinging the pendulum away from fair use. And then they swung back, I think, pretty hard to everything is fair use. And now we were hoping actually for some more guidance, because the United States Supreme Court recently agreed to hear a fair use case that deals with images and the transformative use of images. And so we're expecting next summer a better understanding of what fair use is when it comes to using third-party audiovisual works in connection with your materials. So stay tuned. Maybe you'll have me back next year to talk about the Warhol, the Andy Warhol and Prince cases that are coming up on the court's docket. All right, patents. It's really important to know that I am not a patent attorney. As I mentioned at the beginning, I'm a trademark, copyright, and advertising attorney. That's what I do. It's my bread and butter. But I did want to show you that we do have, this is a recent federal circuit case. In the United States, patent cases go from the district courts to the federal circuit. And so the federal circuit handles all patent appeals. So everybody pays very close attention to what happens at the federal circuit when it comes to anything to do with patents. In this case, it wasn't the game itself, it was the way in which the participants connect to the game. And the reason I brought this one up, in addition to the fact that it came from the most important court, is you have to be really, in my opinion, you have to think very broadly about the patent issues when it comes to gaming. It's not just the gameplay. It's not the four corners of the source code that you have created for the game itself, right? It's all those other issues that Gabriella and Bruno talked about, like how are you connecting to the various platforms? How are you programming for a console? How are you programming for Steam? If this is a mobile game, what is the interaction with respect to your APIs? Is it different for iOS versus Google Play? What are all the different things that are going into the gameplay itself that might have patent implications, like lighting or game mechanics or game economics, which I actually think that's one of my favorite issues to talk about, is game economics. But I think you're going to be seeing some patent issues coming up along there, and how to I wouldn't be surprised about that. So, but it's the patent issues are not limited to the game itself. In a way that I think the trademark and copyright issues tend to be, and advertising issues tend to be about the game, the patent issues could be about almost any technology that's not even necessarily limited to gameplay, but is any sort of utility or design. But speaking of more specifically of utility patents, any utility that affects interactivity, interoperability, and how the game is distributed in a way that you might not be thinking about if you're only thinking about the four corners of the code for this game, for this specific game by itself. Anyway, so that's sort of that's my presentation. I know that was very short on patent law, but we do have only a little bit of time. I do want to mention also that all of these issues are emerging. They're gray areas. We don't necessarily know how things are going to work out. We not only have emerging legal issues, but we have emerging technology issues, which again is one of my favorite things to do. How are we moving the law along with the technology? But at least in the U.S., the tech moves faster than the law, and so we are going to be. We're all keeping a very close eye on VR, AI, metaverse issues, DMCA issues, takedown issues, all sorts of issues with respect to what are the obligations of the platforms versus the obligations of the publishers. What are the regulatory issues that are going to be emerging? How are we paying our programmers? I mean, go talk to a German lawyer about how they have to pay their programmers, and you will get a headache. So there's just a lot of different kinds of exploitation, things that are changing extremely quickly because of the lag between the technological and contractual and creative issues and the legal issues on the other side. Thank you very much. I hope I was comprehensible. I was trying to speak quickly but clearly. Hopefully I managed to at least get some of that clearly. If you have any questions, I'm happy to stay for a couple minutes. Otherwise, this is where you find me. Thank you.
Thank you so much, Margaret. You did it beautifully, so you performed it very well. Thank you again for this broad and also very straight to the point presentation. I enjoyed the opportunity to thank you all, because all of the three presentations were really enlightening and sounds very well. It's like music to our IP practitioner ears. So it's very nice to be discussing here at this International Congress, which is the biggest and the most important IP Congress in Latin America. So I didn't receive by this time any questions from the chat and from the website, but maybe you have time for a very quick question just to finish with, or any comment, any final remark that you're gonna like to share with us, because we are running out of time. Please, I don't know, maybe, Margaret, have any final point to share with us?
I don't know if we have time. Like, I would have a very quick question to Margaret. Margaret, my doubt is, like, considering the expansion and the growth of the gaming industry, as Bruno was sharing with us some of the numbers, would you say that this element of the commercial exploitation of the games would have an impact on the claims based on third-party rights? And I ask that because I think that this would be, at least in Brazil, this would be a relevant argument for AMG in the case that you shared with us against Activision, and also in the Solid Oak Sketches case against 2K Games. I think this would be somehow a strong argument for the claimants. Would you say that this would be relevant in the US? In the US framework?
So with the Humvee case, that's a trademark case. I think that, well, first of all, the Rogers test, that test with the First Amendment is so strong and so well entrenched at this point, it's just very difficult to overcome it. There was an effort last year, a couple of years ago, to bring the case, a similar case, a trademark case, to the Supreme Court that dealt with a television show. That had a similar fact pattern, but it was a television show, and the show prevailed on the issue, again under the same issue, on a similar analysis. That is, that it was relevant to the narrative and not expressly misleading to the consumer. And the argument that you're making, or as I understand it that you're making, was that this has become the whole product placement sort of situation has become so common that people expect it to be licensed, and that it's unfair to lose that licensing revenue. And the Ninth Circuit Court of Appeal said, no, First Amendment is more important, and the Supreme Court refused to take the case on appeal. So I don't think so. So from a trademark perspective, from a copyright perspective, same thing. We've got strong fair use arguments, and I think and with respect to copyright, it's the damages. So if you have to look at the damages, which are the damages attributable to the infringement. And I think from a damages, even if there was a liability perspective, I would be very curious to see what a analysis of the revenue of the profits of a game attributable to the use of a barely seen tattoo on one of the players. Here's your $50, right? Like, I mean, I can't. I think that argument, so even as a practical matter, and of course, here, I should put up my disclaimer, right? I'm only talking as myself, not as many of my clients or of anyone else. But to me, I think it's under both First Amendment analysis in the United States and just as a practical issue of what the scope of the damages might be, it would be difficult to make. But it all depends on the facts of the case, all very fact specific.
Thank you very much.
Fantastic. Thank you so much for that. I would have a couple of questions here, but I will direct it to Margaret and Bruno after our panel, because unfortunately we were without time for anything else. But only I would like to thank you again for all the ABPI staff and our brilliant speakers enlightening us with their knowledge. Thank you again. And for the audience, we have the invitation to share questions after this panel, and also enjoy the whole program of the Congress that covers, I can attest, all the aspects of IP law relevant in Brazil and global trends. So thank you so much again. Thank you again, Margaret, Bruno. It was a pleasure to hear you, and Gabriela for the partnership.